This week we had decisions from two circuit courts that are, to my way of thinking, difficult to reconcile with the circuit's own precedent or with authority from the U.S. Supreme Court. It was the Second Circuit in one case and the Ninth Circuit in the other. First, let's go to the Second Circuit. The decision by Circuit Judge Sullivan held, and this is very important for debtors, that they are entitled to appellate attorney's fees when defending a finding by the bankruptcy court that a creditor violated the discharge injunction. This is a big deal because not all courts have reached that conclusion, and in other recent authorities, the Second Circuit has been very protective of financial institutions when it comes to, let's say, contempt powers of the bankruptcy court for violating debtors' rights. So, this decision from the Second Circuit is a breath of fresh air. The Ninth Circuit decision was a different topic altogether. The Court of Appeals, sitting out in California, held, in substance, that it is relatively easy to hold a creditor liable for violating the Fair Credit Reporting Act if the creditor violates the discharge injunction. This decision, to my way of thinking, is rather difficult to reconcile with some recent Supreme Court authority dealing with enforcement of discharge injunctions. Well, I'll tell you what, this is all very problematic, and there are going to be wide differences of opinion whether either or both of these circuit opinions are, shall we say, wrong. What I do is I invite you to read my column on the ABI website on May 19 and also on May 20, where I report these two decisions and go into some analysis of whether they fit in with either circuit or Supreme Court authority. After you've read my stories, I think it would be a good idea to read the opinions themselves and then form your own judgment. But I tell you, the bottom line for me is this. I think we have the Supreme Court going in one direction and making it difficult for consumers to enforce their rights under consumer protection laws. And then on the other hand, we have these two circuit opinions, one from New York, one from California, giving creditors and debtors some substantial rights to enforce their rights under consumer protection laws. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe. Good day.